Today I'm sending in the motion to vacate all of Hallie Campbell's orders. They're all unconstitutional. It's pretty much the same motion to vacate that I sent Beiersdorf. Beiersdorf, last time I submitted something, he tried to say, "Oh, it has no legal basis," blah 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 blah, and he denied stuff. Well, denying me access to be heard is also a violation of the Constitution. I obviously it shows lack of knowledge on his part, but I'm going to read it to you. So this is what I'm sending today. And this is a motion to vacate under California Code of Procedure 473, and I put final attempt in state court because there's already a lawsuit in federal court. It's being screened right now, but that doesn't mean I'm not going to actively continue to resolve these issues in state court. And I am giving them opportunities to save face because what they're doing is completely out of pocket. It's completely out of their jurisdiction. They're not allowed to do it. So this is what I put. Dear Tuolumne County, Superior Court of California, I request the court to take judicial notice of the fact that I am without counsel. I am not schooled in law and legal procedures. I'm not licensed to practice law. Therefore, my pleadings must be read and construed liberally. Haynes v. Kerner, 404 U.S. Further, I believe that the court has a responsibility and legal duty to protect all of my sons and my constitutional and statutory rights. See United States v. Lee, 106. Introduction. I am writing this motion to address and halt the unconstitutional activities currently occurring within the court system, which are causing significant harm to young children. Over the past year, I have consistently presented evidence, including laws, statutes, case law, and considerations for justice, to demonstrate that this court of equity has been issuing orders beyond its authority. Having resided in Tuolumne County since 1994, I've witnessed ongoing corruption within the judicial system, regardless of changes in judges and government officials. This pattern of behavior has remained consistent, and it became evident to me at the onset of family law matter FL 17431 that the court would attempt to use my child to control my rights as an American. This coercive practice where children are being used as leverage is unacceptable. Throughout this process, I have meticulously documented the illegal acts committed by the mother, the attorneys, and the court. I can provide detailed evidence of the violations, including dates and specific laws breached. For instance, Judge Beiersdorf's actions in grossly overcharging child support constitute violations of 18 U.S. Code 872 and 880, which will be included in my lawsuit. The unlawful removal of a child from a father to impose excessive child support is a clear display of judicial overreach. When Judge Beiersdorf ran for office against Laura, you promised to be a fair and honest judge. I regret voting for you, as Laura Craig has proven to be exemplary in family court, showing compassion and fairness, especially to pro per litigants who lack formal legal education. The current system, which allows for the manipulation of parents' rights, must be reformed. Claim. I will address serious concerns regarding the actions taken by Tuolumne County Superior Court and Commissioner Pimentel, which I believe were wholly out of jurisdiction. These actions resulted in the removal of a 4-year-old who shares a strong who shares a strong familial bond with his father. Instead of ensuring justice, the court allowed an individual who does not act like an attorney, rather a character assassin, Julie Sockel, to disrupt my household. Early in the proceedings, as the records will show, I sought the court's assistance because the mother was withholding our child from me. Rather than addressing this issue, the court seemed to align with her unfounded attacks, leading to the unjust removal of full custody from me without any legitimate grounds. This situation underscores the very reason the Constitution exists, to prevent such judicial overreach and protect individual fundamental rights. The actions taken not only are shameful, but also a disgrace to our country and the Constitution you have sworn to uphold and protect. Any orders made in violation of these well-established laws are void on their face, as no judge has the right to infringe upon these fundamental rights. Additionally, Judge Beiersdorf acted out of jurisdiction when I was placed in his courtroom. He is not a family law judge. This, too, is a clear overstep of judicial authority. I urge you to consider these points seriously and rectify the situation in accordance with the principles of justice and constitutional law. As a pro per litigant currently involved in a federal civil rights lawsuit, undergoing screening in district court, while I recognize that not all parties may be held liable for monetary damages, my primary objective is to ensure that the well-established laws that you have sworn to uphold are diligently protected. In my commitment to justice, I plan to submit a writ of mandamus to Supreme Court. Also, I will forward pertinently evidence of the to the Judicial Council of California and the California State Bar. It is imperative to note that no court, except for a Supreme Court panel, possesses the authority or jurisdiction to issue orders that directly conflict with the United States Constitution. According to the Supremacy Clause, Article 6, Paragraph 2 of the U.S. Constitution, federal law takes precedence over state law and even state constitutions. If any law or code conflicts with the U.S. Constitution, it is the judge's duty to nullify or refrain from enforcing such a law or code. This clause applies universally within the United States and its territories. Here is some case law for your reference into parental fundamental rights. Some of these apply to my case. Meyer v. Nebraska. The Supreme Court held that the liberty protected by the Due Process Clause of the 14th Amendment includes the right of parents to direct the upbringing and education of their children. The significance is this case established that parents have a fundamental right to control the education of their children, which includes the right to choose private or religious schools over public schools. Pierce v. Society of Sisters, 1925. The court struck down an Oregon law requiring children to attend public school, recognizing that parents have the right to direct the upbringing and education of their children. This decision reinforced the principle that parents have a constitutional right to choose private or religious education for their children, and that the state cannot force children to attend public schools. Prince v. Massachusetts, 1944. The Supreme Court recognized that the state has an interest in protecting children. Parents have a fundamental right to raise their children without undue interference. This case balanced parental rights with the state's interest in protecting children, acknowledging that parental authority is not absolute, but a fundamental right that must be respected. Stanley v. Illinois, 1972. The court held that unmarried fathers are entitled to a hearing on their fitness before a child can be taken away, recognizing the parental rights of unwed fathers. This case extended the protection of parental rights to unmarried fathers, emphasizing that parental rights cannot be terminated without due process. Wisconsin v. Yoder. The Supreme Court held that the state's interest in compulsory education did not outweigh the rights of Amish parents to direct the religious upbringing and education of their children. This decision underscored the importance of parental rights in the context of religious freedom and education, affirming that parents have the right to make educational decisions based on their religious beliefs. Sandusky v. Kramer. The court ruled that the state must provide clear and convincing evidence before terminating parental rights, recognizing the fundamental liberty interest of parents in the care, custody, and management of their children. This case establishes a high standard of proof for the termination of parental rights, respecting the importance of parental rights as a fundamental liberty interest protected by the Constitution. Nate Nutting. Guess the Constitution does apply in family law, doesn't it? Troxel v. Granville, 2000. The Supreme Court held that a Washington state law allowing third parties to petition for child custody visitation rights over parental objections was unconstitutional, affirming fundamental rights of parents to make decisions concerning the care, custody, and control of their children. This decision reinforced the principle that parents have a fundamental right to make decisions about their children's upbringing without undue interference from the state or third parties. The Supreme Court has constantly recognized the fundamental right of parents to to direct the upbringing, education, and care of their children, which includes cutting their hair like their dads, Miss Campbell. This right is protected under the Due Process Clause of the 14th Amendment and has been affirmed in various contexts, including education, religious freedom, and termination of parental rights. These decisions underscore the importance of parental rights as a fundamental liberty interest that must be respected and protected by the state. As a longtime resident of Tuolumne County, I seek relief that restores justice and protects my son's welfare. I request the following. Relief sought. Full custody. Transfer full custody from Olivia Phillips to me, Nathaniel Smith. I have provided evidence of Olivia Phillips' abuse, including videos and judicial guidelines defining her actions as abusive. She has been found guilty of 2 counts of such behavior. Vacate frivolous DVRO. Dismiss the unconstitutional domestic violence restraining order issued without proper jurisdiction and proof. The initial hearings did not meet the burden of proof, and improper service by Julie Sockeld further invalidates the order. Dismiss Julie Sockeld's restraining order. Overturn the restraining order granted by Julie Sockeld, which violates my First Amendment rights. Filming in public from a public sidewalk is constitutionally protected. Criminal accountability. Hold Julie Sockeld and Olivia Phillips accountable for felony perjury and other crimes. I will provide all necessary evidence and charges to the court. Removing a child from an innocent parent is unacceptable. Grant restraining orders. Issue restraining orders against Julie Sockeld and Olivia Phillips as I have provided substantial evidence of their wrongdoings. I'm going to continue the lawsuit. Pursue my lawsuit against other parties involved in violating well-established laws of this country. and rights of the people, I seek a jury trial to present a totality of circumstances and evidence in Eastern District Court of California, Fresno. Conclusion. I acknowledge that under CCP 473, a motion to vacate can be submitted at any time. While I am not an attorney, I am a well-informed citizen committed to justice. I will be sending this motion to all parties involved to ensure transparency and prevent ex parte communication. This document will also be shared on social media for public record and documentation for district court and Supreme Court writs. Following the resolution of this motion to vacate, I intend to file for recusals under California Code of Procedure 170.1 for both Hallie Campbell and Judge Beiersdorf. The current lawsuit has created a significant conflict of interest, and both judges have demonstrated bias and discrimination by granting special privileges to a mother while unjustly removing these privileges from me, the father, without legal justification. I put this in bold. The actions of the judges raise serious concerns. Either they knowingly violated constitutional rights or they are unaware of their violations. In either case, this indicates a lack of qualification to serve as judges, whether due to malicious intent or insufficient training. I have lost confidence in the ability of Judges Campbell and Beiersdorf to fairly and competently handle any case of mine, particularly one involving the well-being of a 4-year-old child. The stakes are too high to leave such matters in the hands of individuals who have exhibited such behavior. Please refrain from seeking advice from Julie Sockeld on family law matters. She has a history of exploiting the lack of knowledge among judges in certain situations, leading to adjudications that fall outside of their jurisdiction. For instance, Judge Beiersdorf handling family law matters are beyond his scope, rendering his actions out of jurisdiction. Julie often lacks a proper understanding of family law, fabricating lies and submitting irrelevant evidence in her motions, which lack strong legal basis. It is hard to believe that she could be a licensed attorney given the poor quality of her work. This is likely why she had to hire an attorney for her civil restraining order, which is expected to be overturned in higher courts. I am reaching out to extend the olive branch for the sake of my son. I urge you to reconsider the actions taken in court. As member of the sovereign citizenry, as defined by the California Constitution, I expect judges to act in the best interest of the people who have entrusted them to make fair and just decisions. Our taxes pay for this service, and it is crucial that respect is shown to our children and families. Reform of the family court system is imminent, and it will be more effective when people and government work together. Blatantly violating the laws designed to protect the people will only create a divide. Upholding the oath to the Constitution will improve quality of life for everyone. Historically, this country has fought against tyranny to keep it off our soils. Let us not bring it into our courtrooms. Thank you for your time and consideration. I urge you to act in the best interest of the children involved, setting aside personal egos and financial motives. And then I put some quotes from higher courts. I'm going to go ahead and quote him. It says, "A parent's interest in custody of their children is a liberty interest, which has received considerable constitutional protection. A parent who is deprived of custody of his or her child, even though temporarily, suffers thereby grievous loss, and such loss deserves extensive due process." Interested Cooper 621. Here's another one. Hence, any ex parte hearing or lack of due process would not warrant termination of parental rights. Father enjoys the right to associate with his children, which is guaranteed by this amendment first, as incorporated by the Amendment 14, or which is embodied in the concept of liberty, as that word is used in the Due Process Clause of the 14th Amendment and Equal Protection Clause of the 14th Amendment. Mabra v. Schmidt. Law and court procedures that are fair on their face but administered with an evil eye or a heavy hand were discriminatory and violated Equal Protection Clause of the 14th Amendment. Wick Woo v. Hopkins. Therefore, any denial of parental rights based only on sex is discriminatory. Even when blood relationships are stained, parents retain vital interest in preventing the irretrievable destruction of their family life. If anything, persons faced with forced dissolution of their parental rights have more critical need for procedural protections than do those resisting state intervention into ongoing family affairs. Sandusky v. Kramer. Parental rights may not be terminated without clear and convincing evidence. Sandusky v. Kramer. And then I dated it with my stuff, putting Nathaniel Smith, loving father of Carter and defender of his rights, president of Family Fatherly Freedom Incorporated. So I'm sending this into Hallie's courtroom. today. I'm going to be submitting this to have her vacate this bogus restraining order that Julie was utilizing to create a false narrative. They need to stop bringing criminal elements into family court. What they're doing is they're almost every single family dispute I've seen, they're introducing some sort of a criminal element so that they can circumvent having a jury of your peers. Criminal, when you're charging somebody with a criminal element, that needs to go to a jury. Like that's a part of the Constitution, and they're sidestepping it by issuing bogus domestic violence. Almost every single case of somebody trying to grab custody, they're introducing a domestic violence restraining order, which, if you're found guilty, is criminal. Then it invokes a Family Code 3044, and then what they do is they just tell the dad they didn't rebut it. It doesn't even matter. Like, even if they did, I rebutted mine. I rebutted all 7 pieces of criteria and more because I was told I didn't have to take a parenting class, and I did. I took parenting classes. I'm certified. I've been taking parenting classes. Olivia hasn't taken any. She was also court ordered to go to therapy. She didn't go. Like, that's the thing is, they're discriminating. They're discriminating toward dads. There was a case where I found a mom that was facing the same issues that we were, but her husband was a cop. Her husband was a sheriff, a Tuolumne County deputy. So, and that basically that reaffirms what I'm saying is that Hallie Campbell and David Beiersdorf, because they were criminal, they worked in the criminal court. They're thinking with the criminal attorney mind, and they're allowing criminal elements to be introduced into family court, and that's unacceptable. Family court is not criminal court. It is not the same, and you can't sit here and just automatically assume it's the man's fault just because a majority of criminal cases have men involved. Like, that's not the case for everybody. We are parents. We're not on trial here for crimes. And what the attorneys are doing is they're introducing the criminal element to family court when a couple or when a husband and wife are divorcing, or when parents are just arguing over custody. It's not criminal. Like, why are you turning everything into a fucking crime? Like, that is the whole reason why the Constitution exists, is to prevent that. And you're encouraging it. That's not okay. That is unacceptable. And that is not what you're up there to do. And if you have a problem disconnecting your mind from criminal court to family court, then you're not qualified to do it. You need to find a judge that has worked in family court, and not an attorney that is like Julie or Nate Nutting that is constantly trying to sabotage characters. There's the reason why we have the California Evidence Code 1101 through 1108 is so that bias isn't created by creating a false narrative and trying to claim that somebody, or trying to view somebody and demonizing somebody. That's all these two attorneys are doing, is demonizing the other parent to lose custody. And in reality, if we think about it like a fucking human being, and in reality, that has nothing to do with child custody at all. Like, if a dad had committed a crime 10 years ago and it's been expunged and he's served his time, why is that even being mentioned? That was all prior to when the child was even born. Like, if you're going to sit here and just hold somebody accountable for everything they've done the rest of their fucking life, then let's start digging in your guys' closets, right? Because I can tell you right now, David Beiersdorf and Hallie Campbell have committed crimes. When you violate constitutional law, you're committing a crime. And when you do it under the color of law, it's a serious crime. So if you want to compare who actually has committed more crimes, the judges have committed more crimes than I have. And if that pisses you off, makes you want to retaliate, then that's just proof of pattern. That's perfectly fine. So what I'm trying to tell you right now is the shit needs to stop in family court, because it's just going to be consistent lawsuits back to back. And that does not give you immunity. Right now, David Beiersdorf, he could be completely stripped of immunity right now. The only thing that will save him is if the judge that we get in federal court gives him some leeway. Because on all honesty, what he did, you do not get the protections of the country when you commit treason. When you commit treason, those immunities, they're not there. In fact, there's other judges, and there's even particularly one in California that had her immunity stripped because she decided to physically go out to the person's house and start searching the dude's house without a warrant. You can't do that. That's outside of your jurisdiction. When you act outside your jurisdiction, you lose immunities, because why would the country want to protect you if you're sabotaging the foundations of this country? They won't.